All right, we back at 205 ILCS 670-15-8 from chapter 17, paragraph 5416. Section 15.8, credit insurance. Voluntary credit life insurance, credit accident and health insurance, voluntary unemployment insurance, credit property insurance, or other credit insurance policies approved or permitted by the Director of Insurance, and any charge therefore which is deducted from the loan or paid by the obligor shall comply with the Illinois Insurance Code and all lawful requirements of the Director of Insurance related thereto. When there are two or more obligors on the loan contract, only one charge for credit life insurance and credit accident and health insurance may be made, and only one of the obligors need be required to be insured, except that joint credit insurance may cover two obligors. Insurance obtained from, by, or through a licensee shall be in effect when the loan is transacted. The purchase of such insurance through the licensee or from an agent, broker, or insurer specified by the licensee shall not be a condition precedent to the granting of the loan. Source PA 90 through 437, effective 1198. 205 ILCS 670-15B from chapter 17, paragraph 5417, section 15B, property insurance. A licensee may require the obligor to provide property damage insurance on real and personal property, all or part of which serves as security against reasonable risks of loss, damage, and destruction in connection with loans exceeding an original principal amount of $500. The amount and term of the insurance shall be reasonable in relation to the amount and term of the loan contract and the type and value of the property, and the insurance shall be procured in accordance with the insurance laws of this state. The purchase of such insurance through the licensee or from the agent, broker, or insurer specified by the licensee shall not be a condition precedent to the granting of the loan. The premium charged shall not exceed that charged by the insurance company. B, if the obligor fails to furnish evidence that he has procured insurance on the property, and the insurance may purchase substitute insurance that may be substantially equivalent to or more limited than coverage the obligor is required to maintain. Such insurance must comply with the Collateral Protection Act. I'm going to read that one over. B, if the obligor fails to furnish evidence that he has procured insurance on the property, and the licensee may purchase substitute insurance that may be substantially equivalent to or more limited than coverage the obligor is required to maintain, Such insurance must comply with the Collateral Protection Act. Source PA 90-437, effective 1198. 205 ILCS 670-15D from Chapter 17, Paragraph 5419, Section 15D. Extra charges prohibited. Exceptions. No amount in addition to the charges authorized by this act shall be directly or indirectly charged, contracted for, or received, except 1. Lawful fees paid to any public officer or agent to record, file, or release securities. 2. Costs and disbursements actually incurred in connection with a real estate loan for any title insurance, title examination, abstract of title, survey, or appraisal, or paid to a trustee in connection with a trust deed, and or 2, in connection with a real estate loan whose charges authorized by Section 4.1a of the Interest Act, whether called points or otherwise, which charges are imposed as a condition for making the loan and are not refundable in the event of prepayment of the loan. 3. Costs and disbursements, including reasonable attorney fees incurred in legal proceedings to collect the loan or to realize on security after default. 4. An amount not exceeding $25 plus any actual expenses incurred in connection with a check or draft that is not honored because of insufficient or uncollected funds, or because no such account exists. And 5, a document preparation fee not to exceed $25 for obtaining and reviewing credit reports and preparation of other documents. This section shall not prohibit the receipt of a commission, dividend, charge, or other benefit by the licensee and by an employee, affiliate, or associate of the licensee from the insurance permitted by Sections 15A and 15B of this Act, or from insurance in lieu of perfecting security interest, provided that the premiums for such insurance do not exceed the fees of otherwise could be contracted for by the licensee under this section. Obtaining any of the items referred to in Clause I of Item 2 of this section through the licensee and from any person specified by the licensee shall not be a condition proceeding to the granting of the loan. Source PA 89-400, effective 8/20/95, 90 through 437, effective 1198. 205 ILCS 670-15E from Chapter 17, Paragraph 5419.1. See section, I'll redact that. The Section 15E, insurance. A licensee shall not be considered to be the obligor's agent or broker in connection with the purchase or sale of insurance under this act for any purpose. B. Consideration or another thing of value may be paid to or retained by the licensee or an affiliate of the licensee in connection with any insurance, debt cancellation contract, or other such product purchased pursuant to the loan made or held by the licensee, and all or a portion of the consideration may be included in the amount charged to the obligor, so long as the licensee discloses to the obligor that either the licensee or an affiliate may receive some of value in connection with the purchase by the obligor. Source PA 90 through 437, effective 1198. Right here, 205 ILCS 670 through 16, chapter 17, paragraph 5420, section 16, disclosure of terms of contract. In any loan transaction under this act, the licensee must disclose the following items to the obligor of the loan before the transaction is consummated. So before the loan can even go through. A. The amount and date of the loan contract. B. The amount of the loan using the term account finance. C. Any deduction from the amount financed or payment made by the obligor for insurance and the type of insurance for which each deduction or payment is made. D. Any additional deduction from the loan or payment made by the obligor in connection with obtaining the loan. E. The date on which the finance charge begins to accrue, if different from the date of the transaction. F. The total amount of the loan charge with the description of each amount included using the term finance charge. G. Finance charge expressed as an annual percentage rate using the term annual percentage rate. Annual percentage rate means the nominal annual percentage rate of finance charge determined in accordance with the actuarial, there go that word again, actuarial method of computation with the accuracy at least to the nearest 14th and 1%, or at the option of the licensee by application of the United States rule, so that it may be disclosed with an accuracy at least to the nearest 1/4 of 1%. Excuse me. Annual percentage rate, I'll read that one over, means the nominal annual percentage rate of finance charge determined in accordance with the actuarial method of computation with an accuracy at least to the nearest 1/4 of 1%, or at the option of the licensee by application of the United States rule, so that it may be disclosed with an accuracy at least to the nearest 1/4 of 1%. H. The number, amount and due date or periods of payments scheduled to repay the loan and the sum of such payments using the term total of payments. I. The amount or method of computing the amount of any default, delinquency, or similar charges payable in the event of late payments. J. The right of the obligor to prepay the loan in full on any installment date, and the fact that such prepayment in full will reduce the insurance charge for the loan. K. A description or identification of the type of any security interest held or to be retained or required by the licensee in connection with the loan, and the clear identification of the property to which the security interest relates. If after acquired property will be subject to the security interest, or if other or future indebtedness is or may be secured by any such property, this fact shall be clearly set forth in conjunction with the description or identification of the type of security interest held, retained, or acquired, retained, or acquired. L. A description of any penalty charge that may be imposed by the licensee for prepayment of the principal of the obligation, with an explanation of the method of computation of such penalty and the conditions under which it may be imposed. M. Identification and description of the method of computing any unearned portion of the finance charge in the event of prepayment of the loan, and if the licensee used the rule of 78th method, including a statement explaining such method substantially as follows. They almost give it to you. Unearned finance charges under the rule of 78th are computed by calculating for all fully unexpired monthly installment periods as originally scheduled or deferred, which follow the date of prepayment, the portion of the computed interest that bears the same ratio to the total pre-computed interest as the balances scheduled to be outstanding during that monthly installment period bear to the sum of all scheduled monthly outstanding balances originally contracted for. The description shall also include an example of its application solely for purpose of illustration in substantially the following form. Prepayment rules of 78th. Sum of balances due every month after unearned original times prepayment charge. Sum of balance due every month of contract. For financial charge, excluding any charges added for the first period. I'm going to redact that and read it. For finance charge, excluding any charges added for a first payment period of more than 1 month, or credit insurance charge. Example, 12 months payments of $10. Balance is $120. 1 month is $110. Second month, and so on. $20 finance charge. If 5 payments are prepaid in full, unearned finance charges is $20 times, you see, 50 plus 40 plus 30 plus 20 plus 10 equals 385. 120, there's the example. It says 120 plus 110 plus 100 plus 90 plus 80 plus 70 plus 60 plus 50 plus 40 plus 30 plus 20 plus 10. The term finance charge and annual percentage rate shall be printed more conspicuously than other terminology required by this section. At the time of disclosures are made, the licensee shall deliver to the obligor a duplicate of the instrument or statement by which the required disclosures are made and on which the licensee and obligor are identified and their addresses stated. All of the disclosures shall be made clearly, conspicuously, and meaningful subsequence and made together on either the note or other instrument evidencing the obligation. Where a creditor elects to combine disclosures with a contract, security agreement, and evidence of a transaction in a single document, the disclosures required under Section 16 shall be made on the face of the document, on the reverse side, or other side, provided that the amount of the finance charge and annual percentage rate shall appear on the face of the document. And if the reverse side is used, the printing on both sides of the document shall be equally clear and conspicuous. Both sides shall contain the statement notice. See other side for important information. And a place for the obligor's signatures shall be provided following the full content of the document or one side of the separate statement which identifies the transaction. The amount of the finance charge shall be determined as the sum of all charges payable directly or indirectly by the obligor and imposed directly or indirectly by the licensee as an incident to or as a condition to the extension of credit, whether paid or payable by the obligor, any other person on behalf of the obligor, to the licensee, or to a third party, including any of the following types of charges. 1. Interest, time price differential, and any amount payable under a discount or other system of additional charges. 2. Service transaction activity and carrying charge. 2. Service transaction activity or service or carrying charge. 3, loan fee, periods, finder fees, or similar charge. 4, fee for an appraisal, investigation, or credit report. 5, is charges or premiums for credit, life, accident, health, or loss of income insurance written in connection with any credit transaction, unless 1, the insurance coverage is not required by the licensee, and this fact is clearly and conspicuously disclosed in writing to the obligor, and any obligor desiring such insurance. Or 2, any obligor designs such insurance coverage gives specific, dated, and separately signed affirmative written indication of such desire after receiving written disclosure to him of the cost of such insurance. All right, 6, charges or premiums for insurance written in connection with any credit transaction against loss of or damage to property, or against liability arising out of the ownership or use of property, unless a clear, conspicuous, and specific statement in writing is furnished by the licensee to the obligor, setting forth the cost of the insurance of obtaining if obtained from or through the licensee, and stating that the obligor may choose the person through which the insurance is to be obtained. 7, premium or other charges for any other guarantee or insurance protecting the licensee against the obligor's default or other credit loss. 8, any charge imposed by a licensee upon another licensee for purchasing or accepting an obligation of an obligor, if the obligor is required to pay any part of that charge, is cash as an addition to the obligation or as a deduction from the proceeds of the obligation. Late payment, delinquency, default, reinstatement, or other charge is not a finance charge if imposed for actual unanticipated late payment, delinquency, default, or other occurrence. A license who complies with the Federal Truth in Lending Act, amends thereto, and any regulations issued or which may be issued thereunder shall be deemed to be in compliance with the provisions of this section, except with respect to the disclosure in paragraph M, which may be set forth in a manner. Source PA 90 through 437, effective 1198 205 ILCS 670 16B from Chapter 17, Paragraph 5422, Section 16B. No real estate security in certain cases for loans with an original principal amount of $3,000 or less. A licensee shall not take any security interest in real estate except such lien as results from obtaining a judgment. Source PA 84 through 1004. I'm going to read section 16B again. No real estate security in certain cases for loans with an original principal amount of $3,000 or less. A licensee shall not take any security interest in real estate except such lien as results from obtaining a judgment. I'm going to stop right here, and then whenever we come back, we're going to come right back here. Because, man, my eyes heavy. Peace, y'all.